Alex here with a landlord-tenant video on credit reporting. And I'm just going to specifically cover what I think is something that's only in Nevada. Hopefully it's in the other states too, but I'm just going to go right into it. If you are a tenant and you move out and you get a letter from the landlord saying that they've taken your entire security deposit and that on top of that you're going to owe money for damages that they're claiming that are owed. You can send that landlord a written objection to those damages, basically saying that you don't agree to them. If you do send this letter in writing to your landlord, pursuant to Nevada law, that landlord is not allowed to report the amounts that they're saying you owe them to a credit reporting agency unless they sue you and get a judgment from the court. I think this thing is awesome. I've done it 3 times. I'm happy to do a video on this because I think this is one of those things that people just don't know is a thing. As I mentioned earlier, as far as I know, it's only Nevada. In fact, I usually don't do this, but in this case, I'm going to go ahead and cite the statutes. NRS 118A.242 subsection 5. I'll go ahead and put a link down in the description below. And if you read the subsection, it explains quite clearly that if a tenant receives an itemized statement for whatever damages or something from their landlord, and they send that landlord a dispute in writing or an objection in writing within 30 days of having received the itemized written statement or bill or whatever from the landlord, then that landlord is effectively blocked from reporting it to a credit reporting agency, which I think is great because a lot of times I feel like a lot of the things that get reported to credit reporting agencies, they're really questionable as to whether or not they actually are damages and they can be proven. I don't know about other states, but in Nevada, it's not that uncommon at all for landlords to find any reason that they can find to deprive you of your security deposit. And it's also not that uncommon for other landlords to not only deprive you of your security deposit, but find all kinds of sorts of things to add on to the bill and say that you owe them multiple thousands of dollars worth of money. Sometimes this really comes up in cases where somebody moves out early, and so the landlord will like withhold the security deposit, charge a massive fine, sometimes like multiple $1,000s worth of fine, and then do all kinds of other crazy things. And it's not uncommon in those situations for people to get really ridiculous bills from a landlord. And in those cases, as I've mentioned in my previous videos, you can fight those and win, and it's really not fair that it's going to sit on your credit report because your landlord doesn't want to sue you and they just want to twist your arm and screw up your credit to sort of get you to pay something that you don't think you should have to pay. So in Nevada, you send them this little letter and now they can't report you unless they sue you. And if they sue you, you should be able to dispute those crazy fees and bring up all kinds of other legal defenses for moving out early. That's just that one example. Anyway, please, if anyone here has ever heard of this in their state, please post it in the comments below, because it would be really cool to see that it's not just Nevada that does this, and for the community to sort of have a little bit of a repository in the comments below as to other states that actually do this too, so that other people can reap the benefits of this kind of what do they call it, like consumer protection. Anyway, with that, I'm going to go ahead. Oh wait, I did say that I did it 3 times. I did it myself 3 times. Sent this letter 3 times to 3 different landlords. 2 of the landlords complied with the letter. They did not credit report me, and they did not sue me. So those debts that they said I owed money on, which I didn't actually owe, are pretty much extinguished because they're never going to enforce them. And no one's going to ever know, especially not a credit reporting agency, so that's that. The third one tried to play a little game. They didn't sue me either. What they did was they said that they were in another state and they were a collection agency. And since the landlord assigned the debt to them, they were not bound by Nevada law. I just kind of laughed. I didn't really reply to them. I just said, okay, you can try it if you want to. And they tried to report it to a credit reporting agency. As soon as I found out, I sent letters to TransUnion, Equifax, and Experian. I sent all 3 of the credit reporting agencies copies of my objection letter, along with the Nevada revised statute, and all 3, TransUnion, Equifax, and Experian, struck it from my record. So it didn't work out for that guy. Notice that you can get sued and maybe they'll get a judgment you'll have to pay, and if that happens, well, at least you got to have your day in court. But in my case, I used it 3 times and not one of them sued. So I'm not sure that this is something that a lot of them really bother doing. I think a lot of them just report you to a credit reporting agency and just kind of hope that you'll pay because you want to fix your credit. So with that, I'm going to go ahead and end this video, and I will see you guys next time.